Hello viewers, I am Major General Neelendra Kumar for the playlist Insimilier in conversation with Justice B.A. Khan. The next question that we would like to discuss, and I would request for his views on this, is concerning two doctrines that apparently contradict each other, and they flow from our fundamental rights. One pertains to right to free speech and expression, right to freedom to speech and expression, and the other one relates to the need for a free and fair trial, a fair trial. Now, what is happening in the context of media trial and the right given to the media to cover the court proceedings, that this tends to affect this need for a fair trial. जैसा अब इसके बारे में आप हमारे दर्शकों को बताएं कि आपकी क्या सोच है और क्या सही पोजीशन है कॉन्स्टिट्यूशन में.
And Johnson, there is no denying the fact that media has a right of freedom of expression guaranteed under Article 19 of our Constitution. At the same time, judicial functioning is something which is different from other functioning. And in judicial functioning, first thing is to be taken care of is that it should not be vulnerable or prone to influences. कभी हम मजाक में भी कहते हैं कि एक जज को हवा भी नहीं लगनी चाहिए जी, इसीलिए कहते हैं कि जज को एक हर्मिट होना चाहिए, एक गुफा में कहीं केव में, ताकि वो न देख सके न ये कर सके न. जस्टिस ब्लाइंड भी ऐसे ही कहते हैं कि आंखें बंद करो, ये करो, वो करो. लेकिन जब आपका मीडिया वाला आपके टेबल पे आपका फैसला सुनाता है और बोलता है क्या करो कैसे करो, तो दैट इज़ नॉट ए फ्रीडम ऑफ expression. That's an abuse of that freedom. So many a time this problem arises if you find these days you have trials being held in television studios. You can also hold a trial in this room. And they deciding there what this judge should have done, what this judge should do, what this should be, point should be taken, what point should not be taken. No, this is useless proceeding. They are becoming appellate courts within the television studios. And in one of my debates, I remember that debate, 4 or 5 people, some IS officers, one retired that police officer, IAS, and they were almost questioning and abusing and raising their suspicions against the Supreme Court judge for making an observation. And what was the observation?
And they have no clue.
They had no clue what observation, why is observation made, what is the purpose of making an observation, in what context it was made. Now I was also in that debate. Then I told them, look here, you don't know what the case was. You don't know under what jurisdiction of the court that case was being argued. You don't know in what context the judge made an observation. That, for example, it's a writ jurisdiction in Supreme Court. Do you know anything out of these panelists? Till then, they were abusing left and right that judge for making an observation. Now, that is not an media freedom of expression.
Media trials are often missed.
It's an abuse of...
abuse.
Why does this problem arise? The problem arises out of a misconception. For example, if in judiciary I think that I am the ultimate next to God, as is generally believed the divine duty of judges. Similarly, if a media man believes that, oh, this is my freedom of expression, I can say whatever I can say, doesn't matter. You heard about that in English, that your right ends where my nose begins. So that media man is not trained in 2 things. 1, in the working of the judiciary. 2, how they must train their own reporter staff, whatever, in dealing or reporting in the judiciary. Now, reporting of the court proceeding is sometimes so distorted.
Ji.
And it gives an impression of a prejudgment somewhere. It gives an impression of court going against this or court going against that when the cases are still at the initial stage. So we at one stage, I remember, we organized a seminar on court reporting by the media. A 3-day seminar was held here. And we got experts to tell them that, look here, this is this, there are certain boundaries. Your freedom is not absolute. It is subject to certain restrictions, reasonable restrictions. Reasonable restriction is you can't influence a trial. Reasonable restriction is you can't influence a proceeding.
Sorry.
A court proceeding. But if you do that, then you are crossing the boundary.
So perhaps the need like this is to educate, sensitize the media about the responsibility.
I don't know. At one time I found, for example, you would find certain channels shouting at their highest pitch against court, against judge, against this, against that proceeding. And sometimes I was wondering, why can't that judge act and stop this nonsense in one case which will stop in every other case? But that's not the solution. Solution is both media heads or media authorities and the judiciary, those who have something to do with some knowledge of media, they must sit around a table and work out a frame of work within which a court reporting can take place and stop these studio-based judgment trials. Now, whether it influences a judge or not, yes, it does. Why does judge is a human being? If during the night he finds that all television channels are making a noise on a particular case, hey, this rape or that rape or whatever, the fellow will not grant a bail. That's what our problem today. He is scared of granting a bail in a case which is highlighted by media in their television studios. And that highlighting is not based on anything. That's only to give them those, what is TPRs. TPR. Now, in those cases, our judges do get influenced. It's a nonsense to believe that judge is some kind of a statue and nothing penetrates him. Judge is a human being. He is vulnerable to all this nonsense. If you go on pounding on him, this, tomorrow when he sits in the court, all flashback comes to him.
Although the judges, they claim and they assert
and then
that their teaching and experience tells them to insulate.
For example, you have a case going on and there is a bail matter going on. And bail matter is going on, arguments are still starting, and you have a media trial taking the place in media. This, if bail is granted, then where is the justice, and this. Now that judge, poor fellow, he gets scared. He said, no, this is all gone into the public domain. So therefore, no day. Now, even if he deserves the bail, who? The accused. Even if he deserves the bail on merit, he is not being granted. And we had a problem of this for quite some time. And it is still there. And that is why Supreme Court tells you every day in a judgment, our trial courts must be liberal in granting bail and bond. Trial courts are scared because of this media
No,
thing.
But it is not merely the trial courts. Perhaps the difficulty is now felt even by the high courts that they sort of deny.
True.
So even these judges who are of a superior intellect and experience.
Even in Supreme Court. Now who goes to Supreme Court? Goes people from us, from the High Court. No, they are not something who are totally.
Actually, this is a separate question, but now that we are at it, तो इसका क्या solution है?
इसका solution ये जैसे अमेरिका में उन्होंने किया, दोनों साइडों को मिल बैठ के they must prepare a framework that this thus far and no more. You can't comment on the merit of the case in a television studio debate. If you comment, this is a contempt. And that contempt has to be dealt with. Now those lines have to be drawn.
तो हमको हो सकता है कि हमारा जो कंटेम्प्ट का लॉ है वो भी चेंज करना पड़ेगा इसके
नहीं, क्यों चेंज करना पड़ेगा जी? इसमें क्वेश्चन इज इंटरफेरेंस, यू आर इंटरफेयरिंग इन द जुडिशियल फंक्शनिंग, दैट बाय इटसेल्फ इज अ कंटेम्प्ट. That by itself is a contempt. You only need an assertive judge to deal with it.
क्योंकि हमारा जो नोशन है सिविल और क्रिमिनल कंटेम्प्ट का,
नहीं,
तो maybe somebody else will have to
you are talking of a contempt in case of an implementation of a court order.
जी.
We are not on that. We are a contempt which arises out of interference in judicial functioning. No, if your media interferes in judicial functioning, then it becomes a contempt. Deal with it.
So let an example has to be set.
But who does it? There is no assertive judging. There is no assertive judging. They will cave in.
Right, sir. So this was the actual practical experience which Justice Khan observed while sitting on the bench. Do stay with us. This conversation will continue.